हाँ भाई, तो लास्ट क्लास में अपन ने आर्टिकल 16 स्टार्ट किया हुआ था। तो आर्टिकल 16 अपन देखते हैं। तो सबसे पहले अपन आर्टिकल 16 की जरा एक बार डेफिनेशन पढ़ लेते हैं। आर्टिकल 16 अपन के कॉन्स्टिट्यूशन में कहता क्या है। आर्टिकल 16 कहता है, I have done with the article 15 and some provisions has been left, so I have discussed that I will do it later. But before it, I will do article 16 of the Constitution of India. So what the article 16 says, let's read once. Now, Article 16 says that equality of opportunity in matter of public employment. So basically, it talks about equality in matter of equality of opportunity in matter of public employment. So basically, it talks about a state will ensure to get uh, ensure that every person should get equal opportunity with respect to public employment, that is job, government job, state government job, any other job which has been funded by the government of India, which has been funded by the state government of India, which has been made by the government of India. So all the jobs which has been created by government of India should access to all the persons, and also state will ensure that everyone should get equal opportunity to get access to their job. Now, let's read. In Article 16, there are originally five provisions. Article 16.1, Article 16.2, Article 16.3, Article 16.4, and Article 16.5. Article 16 clause 1, Article 16 clause 2, Article 16 clause 3, Article 16 clause 4, Article 16 clause 5. Now, let's read Article 16 clause 1 first. So Article 16 clause 1 says, there shall be equality of opportunity for all citizens in matter of relating to employment or appointment to any office under the state. So basically it says equality, स्टेट विल नॉट डिस्क्रिमिनेट, या फिर ऐसा बोल सकते हैं इक्वालिटी इन अपॉर्चुनिटी with respect to public employment or any appointment by the government. Now, what the article 16.2 says, let's example अगर अपन बात करें, इसके अगर एग्जाम्पल की बात करें तो रिजर्वेशन इन गवर्नमेंट जॉब, अगर आर्टिकल 16.2 एक बार देखें तो आर्टिकल 16.2 says that no citizen shall, on ground of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against in respect of any employment of office under the state. So basically, it says that no discrimination, no discrimination against any citizen with respect to government job on basis of race, caste, sex, descent, place of birth, residence. Basically, state cannot discriminate to any citizens in government job on the basis of race, caste, sex, descent, place of birth, residence. So this the basically are now we have discussed. I think that some articles are available only for citizens, and the rest all are available also to citizens and as well as non-citizens. Basically, if any foreigner come into India and filed a case that he should get reservation in the government job, then government can deny it because he is not the citizen of India. So basically some article, what are those articles? Article 15, 16, 19, 29, 30. So these article 15, 16, 19, 20, and 30. So basically these are the article which are available only to the citizens of India, not available to the foreign persons, not available to the aliens, not available to the persons who came or out of from India. Now, so we have done with Article 16.1. Article 16.1 says state will ensure to get equal opportunity to all the citizens in with respect to public employment, appointment of any authority. So basically in the reservation provisions. And Article 16.2 says that no discrimination against any citizen with respect to government job on basis of race, caste, sex, descent, place of birth, residence. So basically these are the only ground on which state cannot discriminate. But state can discriminate other than these ground. Basically state can discriminate on the basis of education qualification, state can discriminate on the basis of um, minority, state can discriminate on the basis of other provisions which has not been mentioned in this article. So basically ah once more point that in this article once you read this, then there is not mentioned, there is not mentioned any of them. Let's read. Oh yes, it is mentioned. So state cannot discriminate in these provisions only. Now let's read Article 16 Clause 3. Article 16 Clause 3 is the exception to Article 16 Clause 2. So what is the Article 16 Clause 3 says? Nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government or any local or other authority within a state of office of union territory any requirement as to residence within that state or union territory prior to such employment or appointment. So basically article 16 clause 3 says that parliament can make a law, parliament can make law to give, to discriminate, to discriminate to residents outside of that state, outside of that state or UT. So basically parliament, if let's say if you are the citizen of Uttar Pradesh and there is vacancy has been arisen in the, let's say, in MP. So parliament can make a law and can state that you can't apply on the vacancies which has been arisen in the MP, but it can be done only by law. But because you are not a citizen of MP, so you can be discriminated by the parliamentary law. Is that clear? So state can do so because you are not the, but remember one thing, it can be done only by parliament. It can be done only by parliament. Such amendment cannot be done by the state legislature. So it cannot be done, it can't be done by state legislature. Now let's read Article 16 Clause 4 once. Yes, because in this article they have not mentioned Article 16, in Article 16 Clause 2 they have not mentioned the language as a ground, so state can discriminate on the basis of language. They can make that you can apply on the government job if you know this language. They can apply that if you don't know, then you can't apply. So basically, or they can discriminate that at least 12th criteria should be 12th standard schooling should be done in this language. They can also discriminate on the basis of that. So basically, they cannot discriminate only on these grounds. Other than these grounds, the state can discriminate and do whatever they want. So Article 16 clause 1 says that equality in opportunity with respect to public employment and appointment of the government. Article 16 clause 2 says that no discrimination against any citizen on the basis of caste, sex, religion, descent, birth of place, residence, etc. or any of them. Article 16 clause 3 says that parliament can make parliament by law can make a law to give reservation to discriminate the citizens who are not the part of that residence of that state. So basically, uh, parliament can make provisions to don't allow the persons who are not residents of that particular state for applying in the government job. Now, let's read Article 16, Clause 4 once, then we will move further. Article 16, Clause 4 says that nothing in this article shall prevent the state from making any provision or the reservation for the reservation of appointment of post in favor of any backward class of citizen which in the opinion of the state is not adequately represented in the service under the state. So basically Article 16.4 says that state can reserve seat in government job for backward class citizens if they are not adequately represented. So this is the provisions which has been mentioned in the Article 16 Clause 4. Basically, state can discriminate or state can positively discriminate on the basis of backwardness of that citizens to ensure that they should also get the seat in the government job. So this is the Article 16 Clause 1, 16 Clause 2, 16 Clause 3, 16 Clause 4. I have discussed all of them. Article 16 Clause 3 include the exception with respect to Article 16.2. Article 16.2 says that no discrimination against any citizen on the basis of caste, sex, religion, descent, birthplace, and residence. But Article 16 Clause 3 says that Parliament by law can discriminate to the residents outside of that state in the government job. And Article 16.4 says that state can reserve seat for government job for backwardness of citizens if they are not adequately represented in the government job. Now, we have discussed Article 16.1, 16.2, 16.3, 16.4, 16.5. Let's read once Article 16.5 of the Constitution of India. So what the Article 16.5 says that let's read once. So Article 16.5 says, let's read Article 16.4a. So 16.4a says that nothing in this article shall prevent the state from making provision for reservation in matter of promotion. One second. Now let's read once Article 16.5. Then we will discuss about the Article 16.4a. So let's read Article 16.5. Nothing in this article shall affect the operation of any law which provide that the incumbent of an office is connection with the affairs of any religion or denominational institution or any member of governing body. There shall be a person professing a particular religion or belonging to a particular denomination. So basically it says that law may prescribe that people belonging to particular religion only shall hold office in connection with affair of religious denomination or any institution associated with religion. So basically Article 16 clause 5 says that state can make a parliament by law can prescribe that people belonging to particular religions can only hold office in affairs of religious denomination or any institution which has been related to the religious denomination. Now, these are the basically Article 16.1, 16.2, 16.3, 16.4, 16.5. Article 16.1, equality in opportunity with respect to public employment. Article 16.2, no discrimination against citizen with respect to caste, sex, religion, decency, or place of birth or residence. Article 16.3 says that Parliament can make law to discriminate to residents outside of that state. So Parliament can make law to discriminate to residents outside of that state or Union Territory, because to provide circumstances to person of that state to uh, culturally provide the denomination of that particular state. Now, Article 16.4 says that state can state can reserve seat on government job for the backwardness of the society which are not adequately represented in the government job. Article 16.5 says that law may prescribe that seats can be there that the people belonging to certain religions can only hold office in the institution associated with any particular religion. Basically, for the Hindu institutions, the Hindu people can only hold the office. For the Muslim peoples, for the Muslim institution, the Muslim people can hold the office. For the Sikh institution, Sikh people can hold the office. That can be done by the law. This has been mentioned in the Article 16 clause 5. Now, let's discuss about the evolution of reservation in India. We have discussed reservation. We have discussed the opportunity in the public employment in the government job. Now, uh, let's once discuss about the evolution of the reservation in India. So now I think you have written it down. I have already told you these are the articles on which the citizens, these are the articles which has been provided uh, to only the citizens of India, not to the foreign state, not to the foreign persons who have come into India. Okay, 15, 16, 19, 29, 30. Now let's discuss once evolution of reservation in India. Okay, okay, give the heading. Now, let's once discuss what is the provision at the commencement of the Constitution of India. That is, what is the provisions for the reservation in 1950. What are the provisions in the 1950? Then we will discuss. Then it is easy for me to understand what is the provisions right now. Okay. Okay. Now, first we discuss reservation in legislature. So at the time of 1950, reservation provided in legislature only to only in only in legislature, Lok Sabha, only in Lok Sabha, not in the Rajya Sabha, only in the elected house, that is the house of people, that is the Lok Sabha, and in state legislature. Basically, state uh, reservation has been given to SC/ST, to SC/ST only. So basically, reservation has been provided to the legislature in the legislature, that is in Rajya Sabha, not in Rajya Sabha, not in no reservation in Rajya Sabha or Legislative Council (LC). Okay, so basically, reservation has been provided only in the Lok Sabha and only in the state legislature to the SC and ST community only, and no reservation in Rajya Sabha and the Legislative Council. And this reservation on the basis of the share of population. Now, so reservation in legislature we have done. Now, at the time of 1950, reservation has also provided in the government job. So reservation in government job. So in at the time of 1950, reservation has been provided to ST and ST, to STSC only in central job and state job only. So in the reservation in the government job, these are the provisions which has been discussed. Now in the educational, reservation in education, only central institution, no reservation has been given to any community, to any community at central level, at central university. But reservation has been given at state university. So basically reservation in the education, no reservation at the central level, central institutions, only reservation has been given to the state university, to the SC and ST community. Now, these are the reservation has been provided during 1950. During 1950, reservation has been given to legislature, to SC and ST communities in the Lok Sabha and the state legislature on the basis of share of population. In the government job, reservation has been given to ST and SC community in the government job, central government job, state government job. And also reservation in education has been, no reservation has been given in the central institution, but reservation has been given to state institution, state universities. Now, in the case of Champakam Dorai Rajan versus State of Madras, I think this has been written. So now, in case Champakam Dorai Rajan versus State of Madras. So what is basically happened? चंपकम दोराई राजन एक लेडी थी, तो उसने एक गवर्नमेंट जॉब दिया, अरे सॉरी गवर्नमेंट इंस्टीट्यूशन में एडमिशन के लिए उसने एग्जाम दिया। एग्जाम देने के बाद क्या हुआ, उसके नंबर एक एसटी और एससी कम्युनिटी से ज़्यादा है, फिर भी उसको सीट अलॉटेड नहीं हुई इन इंस्टीट्यूशन। तो वो इस रिजर्वेशन के अगेंस्ट सुप्रीम कोर्ट पहुंची कि भाई there has been violation of my fundamental right to equality. Basically, I am not getting seat, even getting more marks than any other person. So why should I discriminated whether I am getting more marks than any other person? Other person have got the seat in the institution, even he is getting less marks than me. So this has been challenged in the Supreme Court. So basically what has happened in 1920, we have discussed earlier that no reservation has been provided central university, but reservation has been given to state university. So this matter has been happened for the state university. So what is happened in 1920, movement occur against Brahmin community. Therefore, government of Madras provide reservation in technical college. Therefore, reserved all the सी। तो ये प्रोविजन 1920 में मद्रास गवर्नमेंट ने एक ऑर्डर निकाला। ऑर्डर निकालने के बाद टेक्निकल कॉलेज में उसने गवर्नमेंट सीट्स को रिजर्व कर दिया कि भाई पर्टिकुलर कम्युनिटी के लिए इतनी सीट्स, इसके लिए इतनी सीट, इसके लिए इतनी सीट, इसके लिए इतनी सीट। तो ये चंपकम दोराराजन में पहले तो ये एक कॉन्टेक्स्ट था कि हाँ भाई ऐसा था। लेकिन because Champakam Dorairajan says that this is violating fundamental right under Article 14, 15, 29. So basically Article 14 says, I have discussed earlier, and Article 15 we have also discussed. And because this is violating our Article 14, basically right to equality in the institution, and this is also violating our Article 15, and it is also violating our Article 29 too. So what the state says, so basically state says, we will discuss what the parliament, what the in this context, what the state says in its defend. So state says that we are enforcing some DPSP to give reservation in the educational institution. So basically government says that they are implementing Article 14, Article 46. Basically they are holding that DPSP is getting more importance than fundamental right. So basically, if you are implementing Article 14.6, this is the DPSP, and on the basis of DPSP, you have violated the fundamental right of any other person under Article 14, 15, 29C. So basically, they are giving more effect to DPSP rather than fundamental right. So Supreme Court says and it void, declare it unconstitutional to this order। जो मद्रास गवर्नमेंट ने ये कम्युनल ऑर्डर पास किया था, सुप्रीम कोर्ट ने इस कम्युनल ऑर्डर को अनकॉन्स्टिट्यूशनल बोलते हुए इसको अनडिक्लेयर कर दिया। नाउ अब यहाँ पे बात आ गई ईगो की। तो अब पार्लियामेंट एक हाथ और आगे पहुंची। इसके रिस्पॉन्स में क्या किया, इस पूरे केस के रिस्पॉन्स में पार्लियामेंट ने पास किया फर्स्ट कॉन्स्टिट्यूशनल अमेंडमेंट। पार्लियामेंट पास्ड फर्स्ट कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 1951। As they discussed earlier, by the first constitutional amendment act, they have added article 13(1)(b), 13(1)(a), schedule 9, but they have also added article 15(4). So they added article 15(4). What this article says: state can make provision for advancement of socially and backward class and ST community. So state can make special provision for advancement of SC/ST and backward class people. So now they have added article 15(4). So now it's become fundamental right. Basically, state can make special provision for the advancement of the SC and ST community, for the backward class people. Now, it's by first Constitutional Amendment Act, they have bypassed the decision of Champakam Dorai Rajan by the first Constitutional Amendment Act and added Article 15(4). Now, what has happened? What has happened till now? Let's discuss once. So, what has happened? Now, post Champakam Dorai Rajan, अब चंपकम दोराई राजन के बाद क्या सिचुएशन आ गई कि भाई इस केस के बाद गवर्नमेंट का ये कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट आया, इसके हिसाब से क्या सिचुएशन आ गई वो चंपकम केस, क्या सिचुएशन आ गई कि भाई नथिंग इन चेंज, गवर्नमेंट जॉब में तो कोई चेंज नहीं, मतलब पहले अगर अपन बात करें कि अभी तक अपन को पता था क्या कि भाई जो रिजर्वेशन है वो गवर्नमेंट लेजिस्लेचर में है, पहला, दूसरा, तीसरा, तो रिजर्वेशन लेजिस्लेचर में तो कोई चेंज नहीं हुआ, गवर्नमेंट जॉब में कोई चेंज नहीं हुआ, है ना। तो बेसिकली what is the situation right now? So basically no change in reservation for legislature, that is Lok Sabha and state legislature, and also sorry reservation no change, no change, and also in educational institution. Now in educational institution we have discussed at 1950 only ST and SC community got the reservation, but post Champakam Dorai Rajan, after amending the first Constitutional Amendment Act, OBC backward class have also got the reservation. So basically, ST and SC community they are getting reservation already, and backward class also got reservation because of first Constitutional Amendment Act. In the government job, no change. Hmm? Government job, no change. Basically same as, that is सेम एज अर्लियर, जो पहले था वो अभी भी है, लेकिन एजुकेशनल इंस्टीट्यूशन में अब एक एक्स्ट्रा रिजर्वेशन और ऐड हुआ है जो कि बैकवर्ड क्लास को रिजर्वेशन देने के लिए बनाया गया। नाउ अगेन अगेन गवर्नमेंट हैज गवर्नमेंट मेड अ कमीशन, that is Mandal Commission by presidential order. सो बेसिकली गवर्नमेंट ने एक मंडल कमीशन बनाई जो कि एग्जामिन करती, what it commission will do to examine the status of backward class other than ST/ST, and what is the second? Laying down the criteria for identification of, so laying down the criteria for identification of backward class, and also give recommendation for advancement of these backward class. So basically these have to examine by the Mandal Commission. Now we have discussed from here, now we have reached here. So basically, so government has made the Mandal Commission to examine what is the status of backward class, what are the criteria to identifying the status of to identifying the backward class, and also give recommendation for the advancement of the backward class, because it has been done by the huge politicization has been happened in this Mandal Commission for this Mandal Commission. Now let's discuss what has been recommendation given by the Mandal Commission. So what are the recommendation? Recommendation of Mandal Commission. So basically Mandal Commission says that approximately 52% citizens are backward, plus ST and SC communities are 22%, and therefore an backward class is 52% of India. So therefore give 27% reservation to the backward class. So basically Mandal Commission recommended that approximately 52% citizens are backward citizen other than SC and ST. So basically SC ST are 22%, backward class are 52%. So backward class also should get the reservation 27%. Why the 27%? Why not more than 27%? Now that's the question arises. So because why only 27%? Because in the previous judgment of the Supreme Court in MR Balaji versus State of Mysore, Supreme Court already stated, Supreme Court stated reservation cannot exceed more than 50%. So basically MR Balaji, in the case of MR Balaji and State of Mysore, Supreme Court has already stated that reservation cannot be more than 50%. So you have already given 22% reservation to the SC and ST community. So if you follow this decision, then only 27% seats has been left. So you should give only 27% reservation to the backward class of the citizen. I think this will be clear. Okay. So basically, according to Mandal Commission, this recommendation has been given in this. Now, now the question arises how Mandal Commission has determined the criteria of backwardness. It's obvious to determine the criteria of SC and ST community, but what is the procedure? What is the criteria? How I have discussed first question. First question they have done this. Now, what is the criteria? How have you decided the backwardness of any citizen? So for this, Mandal Commission have done a report, a survey. What in how they have done the survey? So for this answer, Mandal Commission recommended that we have done a survey by a survey. How this survey has been conducted? Basically, they have made 12 indicators. What are these 12 indicators? First four indicators are from social indicator, an educational indicator, and economic indicator. So in the social indicator, they have placed 4 points. In this indicator, they have placed 3 points. In this indicator, they have placed 4 points. So basically, there are 12 points which has been mentioned in the survey. Now, on the social indicator, basically they are their backwardness, their richness, their caste, their uh, uh, presence in politics, everything they determined by the social indicator. Educational indicator basically what how many persons in the house has been educated, how many persons have gone to school, how many persons have got the higher educations. And economic indicator, basically they are getting the food, they are getting, they have access to drinking water, or basically they have the house, or basically all these matters has been placed in the survey. And on the basis of presence of each point, they have marked this point, this point, this point, and on the basis of that they identified that on the basis, let's say one factor is caste in social indicator. So social indicator, only one factor is caste, not the reservation has been decided on the basis of caste. Let's think on that reservation has been not based on the caste only. Caste is the only one factor on which reservation has been made. So basically on these all 12 factor, Mandal Commission made that 55% persons are OBC. Now I think it will be clear to you. And what happened in 1990? So this report has been come, and they have also recommended for the advancement, they have recommended give 27% reservation to India. So we have discussed all the recommendation of the Mandal Commission. Now, on the recommendation of Mandal Commission, on recommendation of Mandal Commission, government issued a order and give reservation and gave reservation 27% to OBC, and government also gave 10% reservation to economically weaker section, basically not economy weaker section, economy backward class. economy, backward class. So basically, this has been done by the government order. So on the basis of Mandal Commission, government passed a communal order and gave reservation 27% to OBC and 10% to economically backward class, and already earlier 22% reservation to ST and SC community has already been given. So now 27% OBC reservation has been given, 10% to economically backward classes got reservation. Now, in the contrast of this, case has been gone to Supreme Court of India because they have also breaches the 50% limit of Supreme Court in the case earlier we have discussed. So, in the case of Indra Sahani versus Union of India, Indra Sahani versus Union of India, various argument has been asked in this case. What are these questions has been asked in this case? Let's discuss. So in this case, the first question which has been asked in the Supreme Court, that is reservation violate principle of equality or not? Principle of equality or not? Then Supreme Court stated no. Supreme Court answered no. How? Because reservation is given for the advancement of people. Because reservation is for advancement of people, not for the discriminating purpose, not for negatively discriminating purpose. Therefore, reservation is not violating fundamental right. Reservation is not violate principle of equality. Now, another question has been asked in the Supreme Court, that is only executive order is enough to give reservation? Because I have seen that only government has issued a order, not even passed in the parliament. So the question has been asked, that is executive order is enough for giving reservation? Supreme Court said yes, because Article 16 Clause 4 contains all that to extend, therefore does not require legislature. So they have also stated that communal order is enough to give reservation in the to various communities. Now another question has been asked. There are numerous questions which have been asked regarding to reservation. So the another question has been asked, that are reservation are anti-merit? anti-merit? So Supreme Court also stated no, because reservation promotes inclusivity between citizens. And another question has been asked, can 50% limit breach? Then Supreme Court stated no, 50% limit cannot be breaches. And we have discussed that reservation has been provided, 10% reservation has been provided for the economically backward class. So basically reservation has been given on the basis of economy, not on the basis of backwardness. So another question has been asked, that is 10% to EBC is violated? Then Supreme Court state yes, because reservation can't be given only on basis of economy. And another question has been asked, are caste based reservation is valid? Then Supreme Court stated that reservation has not been provided on the basis of caste. Caste is only the one factor to determine the backwardness of the citizen. Caste is not the only factor to determine the backwardness of the citizen. For determining, caste has been used as a one factor out of 12 factor for deciding the backwardness of person. So it's not a caste based reservation, it's only considered as a one factor for determining the caste, for determining the backwardness of the citizen. So that's the Supreme Court stated. Now Supreme Court also, one question has also been asked in the Supreme Court, can reservation be given in promotion as well? Can reservation in promotion? Then Supreme Court says no. Reservation cannot be given in promotion, because if you are giving the reservation in promotion, that it will be unjust for you, because then it will create an egoistic approach between the department. Then it will increase the tackle between various communities. It will create a hate between various communities within the department. So it will affect the work of the department. So reservation should not be given in the promotion. And there is also one question has been asked, should reservation equal within reserved community? So basically one question has been asked, that reservation in a community, let's say SC. So Supreme Court say, question has been asked that in within the SC communities, homogeneity of reservation within the SC communities, whether they are backward or not, because It is a possibility that within the SC community there are many persons who are not backward, who are more richer. Then how can you say that reservation to the SC and ST communities are homogeneous for all the persons who are belonging to the SC and ST communities? So in this context, Supreme Court stated that within the SC and ST communities, reservations should not be homogeneous. Basically, persons who belonging to particular caste, to particular community, if they are not backward, then they will not get reservation. So basically, if you are not marginalized, if you are belonging to the SC and ST community, and if you are not backward, you are advanced person, then you will not get reservation in the various institution. Now, one more question has been asked in the Supreme Court, that can a reservation should be can a if let's suppose in this particular year 27% reservation has been given to the ST SC communities. Okay, now let's suppose 27% seats has not been filled by the ST and ST community. Let's suppose. So now the vacant seats, what will you do with the vacant seat? So the Supreme Court, so this question has been asked that this seat can be forwarded for the upcoming year. Then Supreme Court said yes, it can be done, but seats can be forwarded, but it cannot breach the 50% limit of reservation. So reservation can be transferred for the upcoming year, but this transfers cannot reach 50% limit in the reservation. So this various questions has been asked in the Indra Sahani case with the Supreme Court, and Supreme Court one by one give its judgment that reservation is not in anti-merit, reservation cannot reach the 50% limit, economically criteria should not be enough to give the reservation, caste caste is considered as only one factor, reservation in promotion no, then it will increase the egoistic approach, reservation is not violating the principle of equality because it's giving for the advancement of the people. And they have also said reservation within the community should not be homogeneous, because if you are making the homogeneous, then within the ST communities there are many people who are already advanced, they will also get reservation, so why should we give him reservation? Now these questions has been asked in the Constitution of India. So in contrast to this judgment, Parliament passed 77th Constitutional Amendment Act. So, so in contrast to this judgment, Parliament passed 77th Constitutional Amendment Act and added Article 16 4A. In this article, they have given reservation in government job So gave reservation in government job, but they also they extended reservation in promotion as well. So basically, by the 77th Constitutional Amendment Act, Parliament extended reservation in promotion as well. Because in the Indira Sahni judgment, Supreme Court stated that reservation cannot be given in the promotion. And by the plus, Parliament also passed 81st Constitutional Amendment Act. Parliament passed numerous Constitutional Amendment Act. First, this has been passed. Second, again, 81st Constitutional Amendment Act has been passed, and they have added Article 16(4)(b). In this, they have said that carry forward carry forward vacancies are allowed and should be treated as separate class of vacancies. Therefore, not considered as the 50% limit. Okay, and they've also passed 82nd Constitutional Amendment Act. And in this Constitutional Amendment Act, they have added Article 335, added a proviso, Article 335, because this is basically allows relaxation in marks in promotion. So basically, in the government job, if there is any promotion, then relaxation will be provided for the various community. So these constitutional amendment has been passed by the parliament. Now they've also done 85th Constitutional Amendment Act, and according to this 85th Constitutional Amendment Act, they have added Parliament added word sequential consequential seniority to Article 16(4)(a). So basically, what do we mean by consequential seniority? We have discussed these. What do you mean by consequential seniority? Let's suppose in 2026, you are at the two persons, which are two persons A and B, which are at the same level. Let's suppose this situation, and in this level, A has senior over B, let's suppose, and A is belonging from the unreserved category, B is belonging from the SC and ST community. Okay, so if A is senior than B in 2026, in the upcoming 4 years, let's suppose vacancies has been arisen for the SC and ST communities. In 2026, A is senior than B, but because of the vacancy arises in the 2027, B got promotion to higher post. Now B becomes senior than A. Because of there is no vacancy for A, so A should not be promoted, but B got promoted because of the vacancy of the seat. Now, in 2028, let's suppose a vacancy has been arisen for unreserved category. So A will be get promoted to this, and let's suppose vacancy has also been arises for B as in ST communities, then B will also be promoted. So now onwards here in the case of 2026, A senior than B, and in this 2027, B senior than A because of vacancies arises for B. So B got promoted, but A did not got promoted. But in suppose in upcoming year vacancies also arises for A. So A also got promoted and B also got promoted. So in 2028, Parliament says that if both are at the same level, then the decision factor will be decided on the what has been happened in the earlier. So basically here now again A will be senior than B. So this is the consequential seniority which has been defined by the Parliament. Now basically this has been this this seniority called as catch up seniority. But what do we mean by consequential seniority? Basically now in 2026, B senior by 1 year and B senior by here 2 years. So by the consequential seniority, there is two types seniority: catch up seniority, consequential seniority. So according to consequential seniority, A is A has been promoted this year, but B has been promoted for 2 years. So basically, for according to consequential seniority, B is senior than A. So initially A is senior than B, but because of some consequences, now B becomes senior than A. So this is very contrasting provisions which has been laid down by the Constitutional Amendment Act. Now these all has been challenged in the M. Nagaraj versus Union of India. So basically, these all cases has been challenged in M. Nagaraj versus Union of India. Now, what the Supreme Court said. Now let's discuss about this. Huh. Okay. Now this has been challenged in the Supreme Court in case of M. Nagaraj versus Union of India. Okay. So in the case of M. Nagaraj, Supreme Court stated Supreme Court upheld validity of all amendment, all constitutional amendment act, whether it is 77th, 81st, 82nd, 85th, all our constitutional amendment act are valid. Plus, Supreme Court also stated reservation is not fundamental right. Therefore, cannot be challenged in Supreme Court. So, Supreme Court also stated that reservation is not a fundamental right. Reservation is not fundamental right. So, therefore, it cannot be challenged in the Supreme. Supreme Court also stated in this case, government, while giving the reservation, must provide sufficient data for backwardness of any class or person. And Supreme Court also stated one more thing, that quantifiable data representing of backwardness of that category. So basically, Supreme Court stated that all these constitutional amendment act are valid, and also stated reservation are not the fundamental right, so they cannot be challenged in the Supreme Court. And also stated, while government giving the reservation to various community, governments to provide the adequate data for the backwardness of that class, and government also provide the quantifiable data represented backwardness of that particular section. Now, in the case of Jarnail Singh versus Union of India, so now another case has been come in the Supreme Court in the case of Jarnail Singh versus Union of India. Supreme Court reiterated its previous judgment, but says no need to provide quantifiable data by government while giving reservation. So basically, Supreme Court reiterated its judgment, which has been given in the M. Nagaraj versus Union of India, and they said that, but they have said that no need of providing quantifiable data while giving the reservation in the various backwardness class. Plus, Supreme Court also stated government should consider a creamy layer provision for SC and ST community. So basically, government should also create a creamy layer provision for within the SC and ST communities. So now, in response to that, in 2019, 103rd Constitutional Amendment Act added Article 15 6 and added Article 16C. According to these articles, reservation has been given purely on economic basis. That is 10% to economically backward, economically weaker section EWS category. So in 103rd Constitutional Amendment Act, Parliament added Article 16C where they gave reservation to economically weaker section by 10%. This is against the Indira Sahni judgment. So this has been challenged in Janhit Abhiyan versus Union of India. Therefore, challenged in Janhit Abhiyan versus Union of India. According to this, Supreme Court upheld the validity of Supreme Court said E 10% to EWS is valid, that you can give the reservation on the basis of economic section, economic criteria. Plus, Supreme Court also stated executive order is enough to give reservation. So Supreme Court also said that you can give reservation only by the executive order. You don't need to pass by the Constitutional Amendment Act for giving the reservation. No, you can give reservation by passing simply a executive order. So executive order is enough while giving the reservation. Now I think it's a little bit clear to you. Okay, now so therefore now Parliament amended again 93rd Constitutional Amendment. So now we have discussed reservation in all aspect in the government job, in this all aspect in this seniority principle, in the uh, legislature or other cases, but we have not discussed reservation in educational institution. So let's discuss once about the educational institution. So we have discussed that, we will revise it again if it is needed, but now let's first discuss reservation. So in 2004, in case of PA Inamdar versus State of Maharashtra, Supreme Court stated reservation can't applied to private education institution because violate Article 19 1G. Plus this also violate, plus Supreme Court also stated that reservation shall not apply to minority education institution. Why? Because they already serving the uh, because they are already serving for the upliftment of the backward class, because they already serving social purpose, and because minority education institution are itself for minority community. So therefore reservation will not apply for the minority institution. In response to this, government passed 93rd constitution amendment, and they added article 15(5). According to this, state can make law and can provide reservation in private institution, including private to ST, SC community, OBC community as well, and EW. But they agree with this provision, but this will not apply for the minority education institution. No, this has been done by the 93rd Constitutional Amendment Act. So therefore, this has been done by the 22nd Constitutional Amendment Act, and this has been challenged in Ashok Mehta versus Union of India, and Supreme Court upheld the validity of Article 15(5). This has been done by the article Ashok Mehta case by the Supreme Court of India. Now we have done with the Article 16. Now let's discuss about the Article 17 of the Constitution of India. Okay. So first let's repeat one things more. So we will discuss this in the second class. Till now